All right, good afternoon, everyone. Welcome to Lunch with Legal. And today we have a special edition for Lunch with Legal. My name is Tillman Heyer. I'm a partner at Heyer Gutierrez LLP. In this Lunch with Legal today, we're going to be covering the Supreme Court's decision in Mirabelli versus Bonta. And this is the ruling that came out this week earlier on the groundbreaking decision as it pertains to parental rights and the transgender disclosure policies in the state of California. And this is a monumental school law decision. And this is also a special edition from Lunch with Legal because we at Heyer Gutierrez are so excited and honored to partner with two other experts in school law, Lindsay Moore and Ethan Rattan. And I'll let Lindsay and Ethan introduce themselves.
Good afternoon, everyone. I'm looking at the attendees, and there's definitely some familiar names, not necessarily faces, but familiar names. So we are excited to partner up with Heyer Gutierrez on an opportunity like this, where we have two very specialized areas where we help our school districts on a daily basis. So we're excited to be able to join Tillman and Marcy with this presentation today. And yes, it is absolutely late breaking news that I think we're going to see evolve over time, but we want to make sure that we're keeping up with what the questions are that you are all likely getting on the front line.
Nice to meet everybody. My name is Ethan Rattan. I'm a junior partner working closely with Lindsay on a lot of primarily HR and some student-related matters. I too recognize some names out there. Hi, everybody. And yeah, this is a big deal, and we're excited to unpack it today and get some of your questions too.
So we got 30 minutes today for our Lunch with Legal, and here's what we're going to be covering right here. So we're going to cover the Mirabelli case, the history of the case, and the procedural background. We're going to cover the Supreme Court's ruling that came out a few days ago. And we're going to really spend most of our time on what I think you all are the most interested in. What are the implications for school districts? And I hate to be a spoiler here, but a lot of this is going to come down to we don't really know yet. But there are a lot of questions. There are some things that are clear and a lot of questions and a lot of uncertainties. And so we're going to be covering what that means for you as school administrators, as personnel administrators, perhaps as service providers, psychologists, and others that work directly with students. And so I want to give a disclaimer here. This is our disclaimer that we give with all our presentations, but especially with this one. What we're talking about here today is not legal advice. It shouldn't be construed to create an attorney-client relationship. Legal advice is always going to be based on a very specific situation, a specific set of facts. And so here we're just talking in generalities about what this could mean for you. But if you need legal advice, contact an attorney. So a little bit of background about the Mirabelli case. So if we go to around maybe the 23-24 school year, summer of 24, there's increasing conversation across the country in different states about the rights of parents, the rights of transgender students, and how these things should be balanced in the context of public schools. And so California passes a few different legislative provisions, and that includes, for example, California has policies that require school staff to use the pronouns, gender pronouns that are preferred by a student. California also passes AB 1955, what is called the Safety Act, that prohibits school districts from requiring their employees to disclose any information regarding a pupil's sexual orientation, gender identity, or gender expression. And so as part of these changes, school districts, of course, are changing their policies and practices to match. And so Escondido Unified, which is the district in question here with Mirabelli, has a policy or a practice that prohibits teachers and staff from sharing the student's gender identity or transgender status to their parents without the student's consent. So two teachers, this starts out as an employment case, two teachers, Elizabeth Mirabelli and Lori West, they bring suit against their employer, Escondido Unified, and both of these teachers have deep religious convictions, and they argue that Escondido's policy that they cannot share this information with students and that they have to honor the students' preferred gender pronouns violates their religious convictions. And so Escondido gives them a religious exemption on the pronouns, but not on the policy of sharing the information with parents. So this is how the Mirabelli suit begins. Later on, a group of parents joins the suit as well. And so the case takes a lot of twists and turns, and it's interesting to see that when this gets to the Supreme Court and the ruling we'll talk about, it's really more focused on the parental rights aspect, even though the litigation started as an employee rights suit. So a lot of twists and turns that we don't have to go over today, but in the Southern District, so the U.S. District Court, this U.S. District Court issues a permanent injunction on December 22nd, 2025. And the text, lightly paraphrased here, is up on the slide. But there's basically 4 parts to the permanent injunction issued by the Southern District. So number 1, school employees can't be permitted or required to mislead parents about the student's gender identity. Number 2, employees can't be permitted or required to use names or pronouns that do not match the student's legal name or the student's pronouns at birth when the parents object to that. Number 3, school employees can't be required to use names or pronouns if it's not shared with the parents and the employee has a conscientious or a religious objection. And number 4, CDE can't interfere with any school employee from communicating to a student's parents about the student's gender incongruity. And so what's important to know, and what we're going to be talking about today, is that this injunction technically does not apply directly to school districts. This injunction was just reached against CDE, the State Superintendent of Public Instruction, and the State Board of Education. Now, of course, it has implications, obvious implications for school districts as well. But if you're looking at just who is covered by the injunction, it's only CDE, the superintendent, and the state board. So here's kind of this background that we've had since the permanent injunction in December. And as you can see, the law and the interpretation of it has whipsawed back and forth in the last 2.5 or 3 months. So right before Christmas, December 22nd, the Southern District issues this permanent injunction on CDE. About 2 weeks later, the Ninth Circuit, so the state appeals it, and the state asks the Ninth Circuit, the appellate court, can you stay the injunction? So can you pause it? Can you put it on ice? The Ninth Circuit agrees and grants a motion for stay pending appeal. And so then the plaintiffs, Mirabelli and parents, they appeal it further to the Supreme Court. And this is what happened on March 2nd, that the Supreme Court vacated the Ninth Circuit stay. So the injunction was in place, and then it was off, and now it's back on. And so what the Supreme Court did is technically, again, a preliminary procedural ruling about should we stay in injunction or should we not stay in injunction. So yes, if we read it very closely, it's not really a final decision on the merits. But also, if you read the decision, the Supreme Court is making it crystal clear. They're telegraphing their thoughts very clearly to everyone, what they think the actual substance of the issue is going to be. And so it really is not going to be a surprise for us if this case ever does go to the Supreme Court on the merits. It is, I mean, the answer, the writing's on the wall, so to speak. And so here is what the Supreme Court says about the merits of the decision. So unconsented facilitation of a child's gender transition intrudes on parent rights to guide the religious development of their children. The Supreme Court said also that any school policies concealing information regarding gender transition or facilitating gender transition during school hours also likely violated the parents' rights to direct the upbringing of their children. And the Supreme Court said that there could be an exception to these foregoing 2 points if there is a potential for abuse if that information is disclosed to parents. And so what you see, again, the language, it's not a final decision. Like I said, the Supreme Court said it's likely that this is in violation of the Constitution. So right, theoretically, it's possible that the case is brief, the justices think about it, and they change their mind. It could happen, but probably it won't happen. And so those are the implications that then are going to trickle down on school districts as well, that the Supreme Court is telegraphing its position on this. So the implications on school districts. So like I said, right, the injunction that now is back in place technically does not apply to school districts. It just applies to CDE. But CDE is the entity that handles compliance complaints. And in the past, on issues of transgender rights, they have addressed compliance complaints, and in some really notable instances, they have found districts out of compliance for policies that pertain to transgender students. And so the injunction now requires them to rule a certain way on compliance complaints about civil rights and parents' rights and so on. And so to know also the plaintiffs in Mirabelli in the case, the specific board policy and administrative regulation that they challenged and that was discussed more at the district court level was the BPAR 5145.3. So potentially there could be compliance complaints, and you know what CDE has to has to find in terms of their legal conclusions on this. So other implications for school districts, the Mirabelli ruling prohibits policy that bar gender identity disclosure. So some districts, Escondido, for example, had a policy that says that school districts, that all employees cannot share student gender identity without student consent, subject to maybe some exceptions. But those type of blanket policies are probably no longer consistent with the Supreme Court's decision. And so I want to address a second point, a second implication as well. I know we have a lot of interest in this decision from school psychologists and other folks that are working directly with students. And how does this interface with confidentiality privileges that pertains to school counselors, or confidentiality privileges that pertain to psychotherapy that we provide in the school setting? So I wouldn't go so far, and I don't think anyone interpreting this decision has gone so far to say that this decision now creates a breach in the confidentiality that we have from those settings. So in other words, if we have a student that, as part of a counseling session, discloses that they have feelings of gender incongruity or gender dysphoria, or that they in fact identify as transgender, if this is disclosed in a confidential counseling or psychotherapy session, those privileges are not really specific to the content of what the student shares, they're specific to the setting. And so those privileges, in my opinion, I think the opinion of most people interpreting this decision, still remain unchanged. And so we might have some future clarification from the court. There's going to be, I 100% guarantee it, there's going to be next phases of litigation on this issue, like how far are the implications of this. Maybe that will address the privileges, but as we stand here today, I don't think the confidentiality privileges pertaining to those type of services have been altered from what we had before. And I want to kick it over to Lindsay and Ethan as well to talk more about some further implications.
Yeah, so this next slide is kind of focused not on the confidentiality concerns of counselors and therapists, but more on just staff in general. And like Tillman just mentioned, we are kind of in a position right now where we're stuck reading the tea leaves of the Supreme Court decision. Like he mentioned, the decision does not affect districts. There's nothing that comes out of that decision or the injunction that the district court has made that requires you specifically to take any direct action. However, there are some things within the Supreme Court's decision that make it clear the types of things that are likely to get districts into trouble moving forward in at least some broad categories. And like you just heard from Tillman, it's going to take months, maybe even years, for the precise district level impacts to play out in federal court for the most part. We're probably eventually going to get, I would imagine, another Supreme Court decision on this. But when I look at the Supreme Court decision itself, and I look at that logic about parent, which is focused again primarily on the parents' rights, the teachers' rights were not really addressed directly by the Supreme Court. There are two kind of broad things that I would take away. The first is that nothing in that decision implies, at least right now, that staff have an affirmative duty, that means an obligation to, without a parental request, notify parents that there has been a change in their child's transgender status, that they were being referred to by different pronouns, etc. There's no affirmative duty to notify those parents. That said, the thing that the Supreme Court really called into question was two sort of broad categories of behavior. And the first is focused on misleading parents regarding a student's gender identity or changes thereto. The examples that are outlined in the injunction, I think, are a good place to start. And that includes if a parent were to ask a staff member right now, is my child exhibiting signs of a change in gender identity, a change in pronouns. The court is pretty clear, I think, that lying to the parent and saying, no, that's not happening, if that behavior were occurring, that is something that I think comes with some risk. And you're going to want to discuss how to address those situations with your legal counsel. Another potential area that's going to be complicated is a lot of districts are tracking students' pronouns potentially in areas in either hidden fields, or there are specific records that are kept out of the student's file regarding the student's transgender status and how those records are being maintained. The injunction specifically mentions that that's potentially going to be problematic, that withholding those records from parents is going to be something that could potentially run afoul of the Supreme Court moving forward. So I would focus mostly on that misleading aspect. And again, I'm not saying that that's not meant to imply, as Tillman already mentioned, that counselors and therapists are going to be handled any differently from a confidentiality perspective. This is more from a general staff perspective. Second, I think there's a fair amount of risk in if a parent goes to a teacher or goes to an administrator and affirmatively states, I do not want my child to be referred to by a particular pronoun or a name that is not associated with their legal name. The decision to do that, to ignore that request from the parent, is going to potentially get raise some questions, I think, and put the district a little bit of risk. Complicating this, though, and Tillman already mentioned this as well, is the Supreme Court did hint at an exception for safety-related concerns, for abuse-related concerns, and how that level of legitimate safety concerns impact the ability of your LEA to, not provide information to a parent or even to withhold information, I think is an open question. That's something you'll want to talk with legal counsel closely on a case-by-case basis too. You can go to the next slide, Tim.
And we know that just on a day-to-day basis, right, this is going to have some impact, but what we're discovering are a lot of other underlying concerns or issues or questions that are coming up as a result of the decision, and one of which is with regards to AB5 and the required training now effective July 1 that we're supposed to be providing to staff teaching grades 7 through 12. And the district court actually specifically addressed the training that CDE had put together, and that's the PRISM training. The district court gave a specific caveat or statement disclaimer, if you want to call it that, that's supposed to be added to that presentation before we start rolling it out to staff or before it is utilized. That being said, we know that not everybody's going to use CDE's PRISM training. We know that there's Keenan training out there and other organizations like that that are providing training. And in those circumstances, we firmly believe there's likely going to be some more work together, probably in conjunction with legal counsel and everyone that is impacted by this decision, to make modifications to those trainings, because I do know that at this point in time, the Keenan training that is currently being provided specifically talks about California law and what California law has told us we cannot do with regards to violating students' privacy rights. Well, that is one of the areas that is going to run directly in contradiction with what we heard from the Supreme Court. So we're going to see, and we're going to have to modify some of the training requirements and training components that our staff are supposed to be receiving. It doesn't, the decision, as we said before too, when Ethan was talking about, who does this impact? It doesn't give direction about the caveat or the disclaimer for third-party training. However, if we are providing that training to our staff and our staff listen to it and our staff believe that what we're directing them to do violates what the Supreme Court has told them we cannot do, that's where we firmly believe on the employment side of the house that we would get some challenges, whether that come from the union as a whole, CTA, CSEA, or whether or not it's individual teachers that bring it up. But as we continue to roll out different trainings and directions to staff, that's most certainly where we see we're probably going to get more questions about, is that okay for us to say? And we're going to be put squarely in the place of how do we align what the Supreme Court has told us with what the state of California has on the books. And there will be some ways to harmonize those two things. But at the end of the day, the Supreme Court gives us some very specific directives, whether it's directly to us or to CDE, we will need to comply, because at a certain point in time, it will trickle down and apply to us on our day-to-day basis and in our policies as well. Go ahead, Tillman.
Yeah, so where we go from here, I think the next steps are probably going to be that CDE is going to issue some guidance. As Lindsay mentioned, the injunction does cover the PRISM training to some extent, so you can expect that to change. CSBA, this is, of course, on the radar of all major industry groups that are supporting school districts. And so potentially CSBA could update their model board policies as well. The case is still procedurally before the Ninth Circuit. So the Ninth Circuit just issued a preliminary stay pending appeal, and the Ninth Circuit still has to address the merits of this. But again, the Supreme Court told us very clearly, this is what we think about the merits of the case. So the Ninth Circuit is probably going to reach the same decision. And if the writing is on the wall, I could imagine there might be some conversations between parties on settling this case. If we look at settlements that have been reached involving CDE on past issues, they have involved CDE taking some sort of position or perhaps co-sponsoring certain changes in law, clarifications to law. That might be the case here. This is, I'm sure, an evolving situation, but these are all possibilities for how this could go on next steps on the case as well.
Yeah, and Tillman, on the point about CSBA policies, I think sometimes we see delays, rightfully so, because while we're unpackaging, CSBA and their staff is unpackaging what does this mean and how does it impact our policies. And as you earlier in the presentation addressed the specific policy 5145.3, which probably a lot of the districts on this call have that particular policy in place. If you look at it in isolation, there may not be a lot of revisions that have to happen. The focus most certainly is going to be on the privacy rights of students, because what we heard from the Supreme Court obviously directly related to parental rights, and it's not focusing as much on the privacy rights or rights of the students, as well as then the use of pronouns. So those are the two key sections, but I would not suggest, and I think in my conversation with Tillman that he would agree too, that this isn't a policy we need to rush out and make revisions to right now. It doesn't have to get on your board agenda, especially since this was not a directive that was given directly to the school districts, number one. But number two, if we come across something that maybe pulls us to this policy to look for how do we address this, it may very well be that we can't enforce the policy, but it doesn't mean we have to be the first one out there running to make these revisions without additional insight and help as things develop in the next week or month.
Yeah, absolutely. And so if we look at possible outcomes in terms of revising the policies as well, you're dealing with an issue that it is so difficult to balance. You have parents' rights, but you also have students' rights. And you're concerned about student safety, but we also have the presumption, which is true almost every single case, that parents are there to love and support and help their students. It was really a difficult decision that I think warrants a lot of deliberation on behalf of school districts, on behalf of school leadership, on behalf of board members, to see how can we reflect the legal concepts, how can we reflect the values that are in our communities, how do we reflect our priority, the priority of every school district to support our students in the best way possible. And so there might be some tweaks that Lindsay mentioned that are going to come down to board policies. And the other questions are too, like how do we interpret this potential exemption that the Supreme Court had some reference to regarding potential for abuse. There are a lot of remaining uncertainties here that we want to talk about as well. And so as it goes with the Supreme Court, there are 9 justices on the Supreme Court, and there are about 1,700 judges in the federal judicial system total. And so as it goes with this decision, with any decision, when the Supreme Court answers questions, they give generalized answers, and they say lower courts go figure out the implications, go down all the rabbit holes. And so we are getting the Supreme Court's ruling now, and we will be going down those rabbit holes, I'm sure, in the months and years to come. And one of those questions that I have, what is the extent of a school's ability to withhold information based on student welfare concerns? So the language the Supreme Court used specifically was potential for abuse. But what if a student says that they are not afraid of abuse, but for example, that if their parents find out about their gender identity, they might commit an act of self-harm? Right, that is something that's unclear, and that I think schools are going to have to grapple with. How do we balance that concern? Even procedurally, how do we know that? Do we talk to the student before disclosing the student's gender identity to their parents? How does that conversation go? There are a lot of little implications that we have to think about as legal counsel to school districts, and for you all as school employees, school administrators, and folks supporting public education. That it remains to be seen how CDD interprets the decision. There are a lot of implications here, and I'm sure Lindsay and Ethan have more to share that I'm questioning, and I'm sure you all are questioning as well.
Yeah, particularly as to this third bullet point here, I think we kind of already touched on that the Supreme Court's decision doesn't really affirmatively require any kind of a disclosure. But something that's up in the air, at least for me, is to what extent does this impact employee rights? Because the Supreme Court's decision essentially punts. It doesn't really make any sort of finding whatsoever on the way the employees' rights played into this. For example, as Tillman mentioned, this case originally began as an employment case. This began as a free exercise and a free speech case from the two teachers, and that hasn't really been spoken to, but will eventually have to come up in the Ninth Circuit when there's a ruling on that. So the extent to which an employee's religious rights and an employee's free speech rights affect their ability to disclose this type of information or not disclose this information. If an employee had a conscientious objection to disclosing it, which Tillman kind of already touched on earlier, I think is something that's very uncertain for school districts, and we're going to have to be patient while that develops.
Yeah, and I think that's one of the reasons why too we don't rush to come up with a particular policy or directive to give to staff. We of course have to communicate with staff. They have to be aware of the fact that how we have handled some of these situations in the past is different. But I would suggest at this point in time that rather than rushing out and saying this is what we have to do, make sure that staff understands this isn't a decision. If you get questions or there's something that you're not sure about, that you're on an island and have to make that decision on your own, to make sure that the dialogue is open so that we can figure out the best way to harmonize our concerns about student safety, parental rights, which we know the Supreme Court has said are very important here, and we need to make sure we aren't violating, along with staff and staff's concerns about the students as well. So what does that mean? I think that means that if a question comes up, staff should have a point of contact that they can reach out to, because one of the other next steps in this is if a parent is saying, no, I don't want you to use this pronoun for my child any longer, the court's told us that we have to comply with, or we should be complying with what the parent's directive is there. But how do we communicate that with the student so the student has an understanding of why we might not use the gender pronoun or name that historically has been used in the classroom? And that is certainly an area where I think our counselors and other folks in those types of positions are probably going to have more meetings with students to make sure that they're there to support them through this change as well.
So by the way, I should mention we have a Q&A function on the webinar. So in the few minutes we have remaining, if you have any questions that you'd like for us to address specifically, type that in the Q&A chat, and I'll be happy. We'd be happy to speak about those. I should also mention when we talk about this, the non-discrimination laws around transgender students also have not changed. So when we're talking about things like bullying, students making fun of each other because of their gender identity, that has not changed at all. There are also, there's just a million questions about this too. I think the intersection with staff and parents and speech, what if parents actually ask that school district use alternative gender pronouns that are not he and not she? Potentially, do staff have to use those pronouns as well? What about staff, if staff have religious objections or religious beliefs that are actually different from the parents' religious beliefs, and then how do we take the precedence there? Because as Lindsay and Ethan mentioned, this really started out as an employee rights case, and the Supreme Court didn't address the part about the employees' rights or the employees' rights to speech. There are just so many implications of this that will be fascinating from a legal side to see how this plays out. And we're going to look also, Lindsay, Ethan, HG, and Kingsley Bogard, we're going to be looking at the implications of this decision. When there are future decisions and future guidance, we're going to look to keep you all updated. I want to also let you know here as we're concluding the webinar, we have some upcoming events. And the QR codes are up here on the slides. We have an onboard with Legal Insights event on the Delta King, and Hire Gutierrez will be hosting that event on March 27th in the afternoon. We're going to be talking about some really fascinating special education related topics. That's on the Delta King on March 27th. We also have our next Lunch with Legal webinar. So this is a Lunch with Legal special edition because we have this new decision that came out a few days ago. Our Lunch with Legal webinar in April is going to focus on the newest OAH cases, and we do this every 1 or 2 months to keep you all updated on the newest legal precedent in special education from OAH. And as with all Lunch with Legals, the price of admission is free. I see here we have a couple questions in the Q&A. How does this decision intersect with clinician confidentiality obligations through BBS? Again, as we had talked about, psychotherapist obligations. So first of all, I want to mention that this decision is based on constitutional rights, and the Constitution is a restriction on what government does. So if you are listening to this and you are in private practice, for example, this does not apply categorically to folks in private practice. But if you are working in the public sector, as somebody working with students, I and most other people interpreting this decision have not interpreted this to have any implications on confidentiality privileges in therapy settings, because those are setting-based and not really content-based. And so if you're wondering how this applies to psychotherapy confidentiality, I would say nothing's changed. We also got a question, will slides be emailed to attendees? And this is a great segue here to connect with us. Hire Gutierrez, we have a YouTube page up here. We post the recordings of all of our Lunch with Legals, so you can send it to folks that couldn't make the live webinar. You can review what we talked about. We'll be posting this in the next few days too, and we'll be emailing the link on YouTube to all the attendees as well. So you'll be able to see the slides as well as our discussion today. And that brings us to the conclusion of our webinar. We are so excited that you all could join us. We're going to be, Kingsley Bogard and Hire Gutierrez are going to keep you all informed as the implications of this play out and as we get more guidance. Again, thank you all for joining so much, and we're so glad we could provide this information to you, and hopefully we'll see you at the next Lunch with Legal and event as well.
Yeah, thank you very much. We really appreciate the opportunity to team up with Hire Gutierrez here, and for all those folks on the meeting today, we know there's questions and there's going to continue to be questions. Should just know we're here to support you in any way that we possibly can. So please reach out if there's other questions that we didn't directly answer during this conversation.